Enterprise AI does not operate in a legal vacuum. Every prompt, output, dataset, model, and vendor relationship can create obligations. In this section, we'll look at the controls that turn legal risk into practical rules for responsible AI use. We've built the stack layer by layer: secure architecture, protected applications, monitoring, incident readiness, and responsible AI governance. The next layer is legal and compliance control, so AI systems can operate safely across contracts, regulations, and jurisdictions. Think of legal controls as the operating boundaries for enterprise AI. They define what data a system may use, which outputs require disclaimers or review, what intellectual property rules apply, and where information may legally move. Those boundaries should connect to specific use cases, roles, vendors, and jurisdictions. Strong programs go beyond policy. They add technical enforcement, contract terms, and audit evidence before launch, then revisit controls whenever the AI system changes. A good AI disclaimer is not legal wallpaper. It sets the operating boundary for the user. Make clear that outputs may be incomplete, inaccurate, outdated, or non-authoritative. Require validation before anyone relies on them for business, legal, financial, medical, employment, or safety decisions. When AI supports a decision, state plainly that accountable human judgment still owns the outcome. The warning also needs to appear where the risk occurs, not buried in terms and conditions. Risk depends on how the AI is used. In regulated domains like healthcare, finance, hiring, insurance, education, legal services, public benefits, and safety, reliance is the key issue. A model may summarize information, but recommending eligibility, diagnosis, or approval can cross into decision support or automated decision-making. Enterprise policy should define those boundaries clearly, then enforce them with guardrails, workflow approvals, human review, and logs that reveal misuse before it becomes a compliance problem. Disclaimers work best at the moments where reliance happens. Before a sensitive prompt, require the user to acknowledge the risk. When the AI returns content, remind them that review is required, not blind acceptance. For higher risk uses, add manager or compliance approval before export or customer-facing decisions. Role-based controls can tighten requirements by function. Keep records of acknowledgements and reviews so the organization can prove the workflow was followed. Copyright risk is not limited to the final answer. It can enter through a user prompt, training set, internal document, external source, or retrieved passage. It can also leave through generated text, images, code, or published materials. That means the review process should check both inputs and outputs. Pay close attention to third-party content, confidential sources, copied retrieval results, and anything being distributed, commercialized, or shown outside the organization. When AI-generated material is ready to leave the organization, treat it like any other publishable asset. Ask what sources influenced it, whether it resembles protected work, and whether attribution or permission is required. The risk changes with the destination. Internal brainstorming may need light review, while marketing, product releases, code, reports, or public summaries need stronger checks. A simple checklist creates consistency, catches red flags early, and gives legal or IP teams a clear escalation path. AI-generated code should pass through the same gates as any other material contribution. Scan it for vulnerabilities, secrets, dependency issues, license conflicts, and similarity to known repositories. Prompts matter too. Proprietary customer code should not be shared unless policy and contracts allow it. If provenance is unclear, generated code may need attribution or may not be usable in a commercial product. Document AI use in the pull request so reviewers can route it correctly. Licensing validation asks a practical question. Are we allowed to use this AI asset in this way? Models, datasets, APIs, and open source libraries can each carry different limits, including commercial use, fine-tuning, redistribution, attribution, retention, or output restrictions. The control is not a one-time legal review. It requires evidence, approved terms, version history, owners, and procurement or software composition checks, so teams can prove usage rights before deployment. AI contracts are part of the architecture. Before choosing an open model, vendor API, or private license, Verify that the terms allow your actual use case: production, customer-facing features, regulated data, and commercial resale. Also check who owns prompts, outputs, embeddings, fine-tunes, and telemetry. Some agreements limit redistribution, sublicensing, benchmarking, or hosting. Safeguards should also cover confidentiality, data processing, breach notice, audit rights, sub-processors, and support obligations. A compliance decision is only useful if it can be proven later. Build an evidence pack for every model, dataset, library, and vendor asset. Keep the license text, version, approval date, owner, and allowed use. Connect that record to model cards, data cards, SBOMs, AI bombs, and deployment logs. Then track obligations such as attribution, notices, source disclosure, restrictions, renewals, and revalidation when assets change or move across jurisdictions. For AI, data residency is not just where the main database sits. Prompts, files, embeddings, logs, backups, monitoring data, and support access can all cross borders. Start by classifying what data is moving, then map every jurisdiction, cloud region, vendor, and sub-processor involved. If localization rules apply, use regional model providers or private deployments. The goal is straightforward: no processing, storage, or access outside the places your laws and contracts allow. Cross-border AI data transfers should be controlled decisions, not simple IT handoffs. Identify the personal data, AI purpose, vendors, and locations involved. Then assess risk, especially for sensitive attributes, automated decisions, or new sub-processors. Choose the legal mechanism, such as contractual clauses or a data processing agreement, and add safeguards like minimization, pseudonymization, encryption, retention limits, and access controls. Finally, approve, monitor, and reassess whenever the facts or laws change. To make enterprise AI operationally defensible, legal controls must be practical and auditable. Set clear disclaimers, review IP across inputs and outputs, validate every license, and control cross-border processing. Together, these disciplines reduce misuse, ownership, and regulatory risk, and prepare us for resilience, manual override, and human factors.